All rise. Court of Appeals, Division 1 is now in session.
Please be seated. Good afternoon, everyone. We're here for oral argument in CV160689, ENGSTROM versus MCCARTHY. These proceedings are being audio and video recorded, so we'd ask counsel that please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel, you're responsible for keeping any portion of your time for rebuttal if you desire to have that done. We have read the briefs. We've discussed this case in conference. And counsel, you may proceed.
Thank you, Your Honors, and may it please the Court. My name is Randy Berghoff. With me is Michael Dinn, and we represent Dana ENGSTROM, the appellant cross-appellee in this matter. This case is about how parenting time orders and decision-making orders will cause mother continued abuse by her ex-husband if those orders are not modified to meet the requirements within the plain language of the statute once there has been a finding of significant domestic violence.
So you want us to send the case back so the court can redo it?
Not necessarily, Your Honor. With respect to parenting time, yes, the parenting time order should be reversed and remanded with specific instructions that the trial court conduct an ARS 25-40303F analysis, which is required when there is a finding of significant domestic violence, which the trial court failed to conduct. With respect to decision-making, the trial court was correct in awarding mother sole legal decision-making because of the finding of significant domestic violence, but it abused its discretion when it imposed specific terms on mother's decision-making authority, thereby creating a de facto joint decision-making.
Didn't your client enter into Rule 69 agreement specifically regarding legal decision-making?
There was a Rule 69, Your Honor, that was entered into in October of 2014. That issue was addressed at the trial court level, to which the judge appropriately exercised the trial court properly exercised their authority within ARS 25-317 and Arizona Rules of Family Law Procedure Rule 69 to reject that Rule 69 agreement.
Under what authority can you reject an order that was already accepted by a different judge?
In accordance with the express language that is contained within both Rule 69 and Arizona Rules of 25-317.
I mean,
those rules give you the opportunity, give the trial court the opportunity to reject the agreement in the first instance. I don't think that it gives it continuing jurisdiction to revisit the agreement, does it?
It does, Your Honor, and if you review ARS 25-317, it expressly states that jurisdiction on issues of parenting time, support, decision-making do stay with the trial court, and in accordance with the Anderson v. Anderson case, courts can reject agreements with the parties if the orders are not in the best interest of the children.
I didn't mean to suggest that I don't think the court has continuing jurisdiction over custody issues. What I meant to suggest is that there is a point of finality in a court's order. And a court doesn't have the ability to sua sponte revisit its decision to accept an order under the express language of the rule. If you want to argue that that authority comes from somewhere else, that's fine, but I don't see that written into the rule.
Certainly, Your Honor. So in addition to the rule, as I stated in the Anderson v. Anderson case, it does hold that the courts can reject agreements of the parties if they are not within the best interest of the children, is exactly what the trial court did here.
Well, hold on, but that goes right back to what Judge Portley just asked you, is what authority does one judge have to overrule another judge's determination? I thought Judge Bailey made that determination and said accepted it.
She did accept the Rule 69 agreement, and of course, as you know in review of the record, mother believed that was a temporary order, father believed it was a final order. The trial court did find it a final order, but found that she had the authority to reject the order because of the evidence that was presented to her with respect to the domestic violence allegations that were put before the court.
No, but doesn't the parties waive at the time of the Rule 69 agreement whatever may have had occurred before? Now, if there's stuff that happened separately, the court may well consider that, but you don't get to say, I'm going to enter an agreement, but, oh, by the way, there are reasons for a different judge not to accept them.
Not necessarily, Your Honor. And in accordance with our Supreme Court case, the Cone v. Rigetti case, they have recognized that family courts can change final orders if material facts existing at that time of the agreement were unknown to the court.
Well, but generally it's based upon fraud or misrepresentation as to the 69. Hopefully, presumably, the parties knew how they behaved toward each other prior to the time of the 69 agreement.
The reality of it is that mother had the ability, first and foremost, mother believed that those agreements were temporary agreements. And I understand what the trial court found with respect to that, but case law does suggest that she has the ability, especially if it is past abuse and continuing abuse. And in addition to that, if the court had the authority under 25-317 to reject the Rule 69 agreement, then she had the ability to hear that evidence, which is exactly what she did here.
Well, wait a minute. If she accepted the agreement, and we believe that that is a final determination as it relates to that agreement, doesn't mother have to show that there's been a substantial and continuing change of the evidence that would warrant modifying that agreement?
Mother does if she was petitioning the court for a modification. Mother does not need to show that if the court is going to reject that agreement because they find that it is not in the best interest of the children. We're
going in circles here because one judge has already rejected that or found that it was in the best interest of the children.
Certainly, pursuant to the evidence that she knew at that time.
Who asked that the agreement be rejected?
Excuse me, Your Honor.
Who asked that the agreement be rejected?
No one asked that it did. The court did so under its own ability in accordance with Rule 25-317 that says that the court on their own on their own motion or on request of the court that they can do that. The reason why there was no petition to modify before the court with respect for mother's position as it related to the Rule 69 agreement is because she believed it was temporary.
So every Rule 69 agreement that's been made in Arizona in the last 18 years is subject to sua sponte vacation by a court upon the request of nobody?
Upon the request of the court's own motion, the rule allows the court to be able to do that, especially if they're learning facts that are contrary to the best interest of the children, which is exactly the trial court learned here. The trial court learned facts about the domestic violence, and when the second judge reviewed the Rule 69 agreement, believed at that point that it was not in the best interest of the children. That was facts that the trial court did not know at the time when that Rule 69 agreement was entered into.
But your client in this case filed a pretrial statement specifically requesting that that be done, correct?
That what be done, Your Honor?
That it should no longer go along with joint legal decision-making, but it should be sole legal decision-making for mother.
Yes.
And that pretrial statement also alleged that there had been significant domestic violence.
It did, Your Honor.
So why isn't that just a petition to modify?
Because she believed that the Rule 69 agreement was temporary.
Well, did you provide us the transcripts of that proceeding?
From the October proceeding? I would have to review, to know whether it was a part of the record or not.
Okay. Would it surprise you if I told you they were not?
Would I be surprised to know? I don't know, Your Honor.
So since we don't have a record of what transpired at when the Rule 69 agreement was entered into, don't we have to presume that it was a final order?
Well, Judge, the trial court found it to be a final order, but at the time mother had gone to trial in July of 2016, the reason why a petition for modification was not before the court was because she believed and presented evidence that it was a temporary order. If it had been found a temporary order, the need for a modification would not be there. As it relates to the issues that mother has up on appeal, the trial court, following their finding of significant domestic violence, made two significant errors that were vital to this case and contrary to statutory law. As I discussed, the trial court erred in awarding equal parenting time because an ARS 25-40303F analysis is required once there is the finding of significant domestic violence, which the trial court failed to conduct. I also discussed the errors that the trial court made with respect to decision-making when it imposed specific terms onto mother's decision-making authority. Mother requested
Well, with parenting time, the statute seems to be a little confusing. It says the court shall consider some things, and then it says the court may, and then list a number of things. Is that shall a shall, or is it a may?
Well, in accordance with, so if we're talking just about parenting time, and we have found that there is domestic violence has been found and that domestic violence is significant in nature. If you look at the F provision of 40303, it reads that if the court finds that a parent has committed that act, that parent has the burden of proving to the court satisfaction that parenting time will not endanger the children or significantly impair the child's emotional development. If the parent meets this burden to the court satisfaction, the court shall place conditions on the parenting time that best protect the child and the other parent from harm.
And then it goes on to say, right after that, the court may.
And it may consider those things in terms of what the conditions would be. Those are related to the conditions, not shifting the burden on. And by the way,
But if the court found that, then the court could, in fact, decide in its discretion that there'd be no conditions.
Certainly.
If the court finds they're not if the best interest of the children would not otherwise be harmed.
certainly there is the statute requires the court to conduct the analysis, which requires the burden to shift to the perpetrator, which this court did not conduct.
How do we know that?
Because the record doesn't show it. And in accordance.
Well, but can't a judge, as they're thinking and writing up, make that determination without outlining it?
Your Honor, absolutely not. In accordance with ARS 25403 and this court's holding in the Knoll v. Knoll case, the trial court is required to make specific findings on the record when addressing issues of parenting time and decision making. It would be required by the trial court to show that they conducted that analysis in coming to their conclusion with respect to parenting time. And the court did refer to statutes in their finding of parenting time. Unfortunately, those three statutes, whether specifically cited or language used from the statutes, were not the correct ones when addressing parenting time if there was a finding of significant domestic violence. Those statutes relate to parenting time and decision making when there is not domestic violence, or it relates to decision making in general. So the trial court would need to conduct the analysis and would need to make specific findings on the record that they did conduct that analysis. And that is absolutely not what the trial court did here when it entered its parenting time orders. Therefore, we request that be reversed, remanded back to the trial court with specific instructions that the F analysis be conducted in this case. As I stated, with respect to decision-making, the trial court was correct when it awarded mother sole legal decision-making, but it abused its discretion when it imposed specific terms on mother's legal decision-making authority. In accordance with ARS 25403-03D, decision-making given to the perpetrator is contrary to the best interests of the minor children, and there is a burden shift that requires the perpetrator to prove to the court whether or not that decision-making, if they were requesting it, would be in the children's best interest. And the trial court specifically found on the record and in its orders that father did not rebut that presumption. Therefore, the award of sole legal decision-making was correct. However, the court imposed 2 paragraphs worth of specific terms that created a de facto joint legal decision-making, which is contrary to the intent that ARS 25403-03 outlines. Specifically, and this is problematic because a victim of domestic violence mother is not only required, but she is now court mandated to communicate with father related to the issues when addressing major issues related to the children, all of those decision-making issues. And if she doesn't do that, then she gets in trouble. She's not only further abused by her abuser, but now she's being abused by the judicial system because the specific terms are contrary to the finding of significant domestic violence.
But aren't they going to ultimately have to communicate about the children because they're going to be parents for a long time?
The communication differs. Had mother been awarded your traditional sole legal decision-making, perhaps she would have to keep father informed. But that's not what these specific terms do. And if you carefully read the specific terms, they require mother to do things like making a good faith effort to communicate with father, to reach a joint decision with father. And if she cannot do that, she has some sort of preemptive authority to make that decision, but father can ask the court to review that. And there you're just having the continued abuse of cycle abuse.
Well, but if in fact she makes the decision without asking father, can he challenge that anyway?
I suppose he could, but I think that the burden is a little bit different there. I think that you may be looking at a petition for modification, which then has the year requirement, which has the change in circumstances requirement. The problem with these specific terms is it basically throws the the defining of domestic violence out the window, because this isn't about what remedies father has available to him to seek assistance from the trial court. It's that mother is court mandated to have that conversation with father, and only then can she make that preemptive decision. And then at that time, father can still challenge her. So it is a continuing cycle of abuse. And to remind the court, father's acts of domestic violence that were found by the trial court include things such as manipulation, coercive, controlling, harassing behavior, using the children to traumatize mother. And with these specific terms, that only leaves that open, that domestic violence and the continued domestic violence is not only likely, but it becomes inevitable.
What facts would the court point to that show that this was significant, as opposed to the fact that he may be a bore and a bad person and maybe even a bad husband, but how does the court articulate that they were significant?
Certainly, Your Honor. So the court, in conducting its ARS 25403 analysis, if a party alleges domestic violence, the trial court conducts an additional analysis under ARS 25403-03, which is exactly what the trial court did here. In accordance with the C provision of that statute, it gets a list of 7 items that the court can look at when determining whether or not there's domestic violence.
Well, I'm not worried about the domestic. I'm worried about the significant.
Certainly, Your Honor. Then that goes to the A and B provisions of ARS 25403-03. The trial court has the discretion to look at all of the evidence that's being presented before it in order to make the determination as to whether or not the domestic violence was significant in nature. Specifically contained within the A portion of 25403-03, it reads that if the court finds by a preponderance of the evidence that there has been a significant history of domestic violence, and that is exactly what the trial court found here, that after review of the evidence and the testimony that was presented to the trial court, it made a finding that father had engaged and was a perpetrator of acts of significant domestic violence. One of the issues that father does have up on cross appeal is that the trial court inappropriately found that he engaged in those acts of domestic violence and that the trial court failed to conduct the appropriate analysis and is requesting this court to review that de novo. But under no circumstances should this court reverse that trial court's ruling. First and foremost, father misstates the standard of review here because the trial court did conduct the appropriate analysis, as I just stated.
Oh, but the standard of review is just really simply an abuse of discretion.
If even, Your Honor.
Yeah, and if there's been a misinterpretation of the law, that could well be an abuse of discretion.
Certainly, Your Honor, but father is specifically asking this to be reviewed de novo. And second, in accordance with the Heard v. Heard case, the court shall affirm the trial court's ruling if substantial evidence supports the record and the trial court's findings. The record clearly supports here that father did engage in acts of significant domestic violence. As I stated, the trial court found by a preponderance of the evidence that there had been domestic violence by father and that was significant in nature. Therefore, the issue of domestic violence should not even be addressed by this court at all.
So, in our review, should we be ignoring the Rule 69 and whatever may have happened prior to that? And your argument is we look at everything despite the fact that the parties into our 69 agreement.
Yes, Your Honor, because in accordance with what the trial court found in ARS 20...
Well, let's say, but if the trial court is wrong, then we only look at post-Rule 69 problems.
If the trial court were wrong, but the trial court was not wrong, it had the authority to reject that Rule 69 agreement.
Say we disagree with you. Is there evidence in this record that would indicate that there was a substantial and continuing change from the time the Rule 69 agreement was entered until the time of the hearing, which would warrant a finding of substantial domestic violence?
Certainly, Your Honor. That was not something that was pled before the court because, as I stated earlier, mother believed that that agreement was temporary in nature. Therefore, a petition for modification, which gets you to the showing and change of circumstances.
Counsel, you're not answering my question. My question was pretty simple. Is there evidence in this record that would show from the time the Rule 69 agreement was entered until the time of the hearing there was a substantial and continuing change? I understand your legal argument. Could you answer my question?
Certainly, Your Honor. It would have to address whether or not the court found that the domestic violence that occurred during the marriage continued to occur once the parties were in the middle of their 2-year dissolution.
And do you believe it is in the record?
I do believe that there is sufficient evidence for the court to
After
have.
the Rule 69 agreement was entered.
I would have to review the court's findings, but I do believe that there was testimony that presented of the domestic violence. Most of which may have occurred prior to the Rule 69 agreement, but it was continued domestic violence that had occurred after the Rule 69 agreement had been
Is there
entered into.
evidence on the record of a specific incident of domestic violence after the agreement?
Not that I can recall, Your Honor, because I believe most of the domestic violence had occurred prior to that date.
Okay.
At this time, I would like to reserve the remaining time that I have for rebuttal.
All right, thank you. Counsel.
May it please the court, my name is Stanley David Murray. I'm the attorney for the appellee cross-appellant James McCarthy, who was the respondent in the lower court proceedings. Seated with me at counsel's table is Ruth Lusby. She's co-counseled in the appeal, and she also represented Mr. McCarthy in the trial court proceedings. I'd like to start with our issue on cross-appeal. We believe, and I believe the court's going in this direction as well, that Rule 69 agreement was a final order. And so it was incumbent upon the petitioner.
Well, the trial court's accepted it as a final order, and there's nothing in the record, as I've seen it, that would indicate anything to the contrary.
That's correct, Your Honor. And so it was incumbent upon the petitioner to show a change of circumstances since that date. And in regard to Judge Murdy's last question, was there any evidence to suggest that any of these events occurred after? If you look at the testimony of Dr. Messing, who really was the only person that testified about domestic violence, she specifically stated, I don't keep track of dates. I don't know when these things occurred. I just keep track of a continuum. So there's no specific evidence to show that any of these events occurred after the date of that October 2014 agreement was entered into and made into a final order. More likely than not.
Well,
Sorry.
wouldn't a court have discretion if the issue was raised to listen to the testimony and then make its determination, and if it needs to reconsider an earlier decision, that it could do so?
If it was properly presented, yes. First of all, we don't have a separate petition under 25411.
Well, but why would you need one? Because the parties are still in their current state of dissolution, and here's a trial. The court gets to hear all of the evidence and then use that statutory framework to determine whether or not there needs to be a change.
Because you have to have proof of a change of circumstances, which wasn't even alleged in that joint pretrial statement. I agree the issue was raised.
Well, but
we
it was
shouldn't.
raised to show that at least prior, there was no allegation in the petition of domestic violence, but it was raised in the pretrial statement.
That's correct. But it wasn't alleged properly, and it wasn't presented, the evidence wasn't presented to show that these events had occurred after the date of that agreement. So that's why we raised that res judicata collateral estoppel issue. Mom could have raised the domestic violence issue in her petition, could have raised it in her RMC statement, and could have raised it at the RMC hearing if it really existed, but she didn't. And even at the trial, she didn't present evidence to show that these events occurred after the date of that agreement. Remember, the parties are separated for 2 years now. They've been exercising joint legal decision-making and equal parenting time. There's been no problems. Dr. Gahn reported no problems. Dr. Messing was not entitled to testify about any parent-child relationship issues. All she could testify about was domestic violence. So because this record is so devoid of any proof of events occurring after that Rule 69 agreement was made in order, this court has to reverse that finding of domestic violence. And again, the finding of sole
Well, if we were
legal
to reverse
decision-making.
it, wouldn't we just send it back and let the court have a hearing to determine whether or not there was anything, based upon your argument, post Rule 69, and then make whatever determination results from that finding?
Well, Your Honor, I don't think you get a second bite at the apple. And it was your responsibility to bring that evidence up at the trial. And because you
But
didn't.
if they can, in fact, at this point in time, figure out how to divide what happened before the Rule 69 and after the Rule 69, why couldn't they do it when, if what both parties want, in some steps, or send parts of it back?
Well, if you want to send it back, that's fine with us, Your Honor, because we would like to have it reversed. But it seems to me that this record is complete as is, showing no domestic violence after the Rule 69 agreement if it even existed beforehand, that I think it's a fait accompli, if you will, that this issue is moot because it hasn't been proven. And by granting another retrial on an issue that should have been presented before, I don't think would suffice, just in my opinion. So that's the first legal error that Judge Ryan Toohill made, was not honoring that order. She didn't have the authority to reject it. Going on to
But
the...
because of the evidence, then, can't she then, while not rejecting it, take another look and to see whether or not, based upon that, the notion of the best interests of the children have changed as a result of the parents' relationship, especially if any of it was post Rule 69?
Well, you had the uncontroverted testimony of Dr. Gahn saying that this isn't domestic violence and that the children's best interests require equal parenting time. I don't know. Again, I don't want to belabor the point.
But if the trial court was conducting the wrong inquiry, taking your position as valid for a moment, that the Rule 69 agreement was a final order, and so the trial court was conducting the wrong inquiry, if you're successful in getting it reversed, wouldn't the trial court be able to take the same evidence and take it up under the auspices of the right inquiry under 25-411 without violating principles of former adjudication?
Well, if you give them a second bite at the apple, like I say, that they would rephrase their petition to allege that change of circumstances when they should have done it before, I'm saying
well, but
they're foreclosed.
they could have, if we never had this case, there could always be a 411 petition, right?
Certainly.
So when you say a second bite at the apple, I think the statutes contemplate that we can at least look at the apple from time to time, and evidence that might provide context for the allegations of the petition is probably going to be admissible. Do you disagree with that?
Well, I guess the distinction I'm making is because you had your day in court, though, to present that evidence, whereas now we're going to remand it and let you try it again, which
Yeah, but-
I don't think the law allows.
Well, except it does allow it, because 411 specifically says it. You can bring in evidence that was presented prior to the last order entered by
Sure.
the court. If we're talking about the last order entered by the court is the Rule 69 agreement, then evidence that was presented or possibly presented could modify the original order, right?
Yes, sir, but they did attempt to modify it, and they were successful. And now that's the last order, which I'm asking you to reverse. So you see, that original...
But we're asking you that even if we determine that Judge Toohill didn't make the right connection, shouldn't she make the first inquiry of whether or not there was evidence after the 69 agreement?
Yes, sir, she should have, and she didn't, so it's an abuse of discretion. And maybe I can answer your question better this way by pointing out that this wasn't even domestic violence in the first place. Coercive control is not defined under the statute as to what domestic violence is. 133601 has a listing of so many crimes. In fact, legislature is adding to that list every day with modern technology. But it doesn't include anything to the effect of coercive control, and nor does it say, trial judges, you have discretion to determine what domestic violence is. Dr. Gahn, sorry?
So you think we can use both the definition in Title 25 in the domestic violence provisions as well as the Title 13 provisions?
Yes, sir. I think the legislature has spoken on what domestic violence is, and that's what the court should have followed.
And the court then could make that determination of that evidence by a preponderance of the evidence if sufficiently demonstrated.
Correct. We don't need expert witnesses to tell us what domestic violence is. Maybe expert witnesses can testify what the effects are, how it affects children, how it affects relationships. But the legislature has spoken as to what domestic violence is. And so for that reason, we believe Judge Ryan Toohill, I'm asking for the standard of review to be de novo, because she didn't interpret the statutes incorrectly. She made an incorrect legal conclusion that coercive control is domestic violence, and we're asking the court to consider that as a basis for setting aside that finding. The judge found no physical or sexual violence, and the events that she lists, if you look at page 20 of her decision, IR 82, there's a paragraph where she says, he forced her into online sexual activity. Well, that must have occurred during the marriage because they've been separated for 2 years now, so that's not ongoing anymore. One of the other things was that he was going to have sex with prostitutes if she didn't meet his demands or have sex with somebody else. You're right, he's a tool, but he's not a perpetrator of domestic violence if that's the way he's treated her. It's not the best thing if it's true that that's what happened, but it doesn't go to the level of domestic violence. So we're asking the court to determine that Judge Ryan Toohill was incorrect in her legal conclusion that domestic violence had occurred here. And then especially the significant finding, a significant history or significant acts of domestic violence is definitely not supported on this record.
Well, based on your argument, do not support it, at least, as statutorily defined.
Yes, sir. And then what are the consequences of this alleged domestic violence? Even the court was perplexed. The mother was saying, I'm in perfect health, fine mental health, fine physical health to have custody of my kids, but yet there's no stress or no syndromes related to this domestic violence that occurred over this substantial period of time. So the court was even confused and perplexed on mother's position in that regard.
Well, that's not something for us to speculate about, though, is it?
Well, you don't need to speculate about it because Judge Ryan Toohill made a note of that in the record.
Well, I guess I question the propriety of even examining that issue. If we're trying to define domestic violence, do we say that all is absolved if one recovers?
Well, I'm going to defer to Dr. Gahn because in Dr. Gahn's testimony, he said there were no consequences to mother as a result of this alleged domestic violence. You'll see that in the transcript. So not in my opinion, but based on his opinion as to what domestic violence is. And by the way, he's certainly qualified to render an opinion on that.
Well, but it wasn't based on any testing. It was based on his observations.
Well, remember, he couldn't do the testing because mother wouldn't cooperate.
I understand, but it also seems that, for the most part, the trial court didn't accept his analysis, even though it's there.
Right. The trial court didn't agree with him that it was ridiculous, but I guess that's for you to review and decide, too. The other issue I wanted to bring up was the equal parenting time and the joint legal decision-making. Again, I'm not in favor of having this court affirm the legal decision-making decision, but the court did give mother sole legal decision-making authority. Father has no say. He gets to find out what mother has decided, but he can't overrule her. He can't force her into negotiation or mediation on that issue. He has to go to court and challenge it and show it's not in the best interest of the children. So she has sole legal decision-making, and that's what we're asking the court to reverse by reversing the finding of domestic violence. On the equal parenting time issue, we want that to stay in place because the kids are used to that. There's been over 2 years of party separation where the children have been going back and forth on a weekly basis. Dr. Gahn again said that this is the perfect arrangement for the children, that it's in their best interest, and having dad go through supervised parenting time would be devastating to the children. So again, uncontested facts in this record, opinions in this record, that this court should adopt and affirm that part of the decision at least. And there were conditions imposed on equal parenting time. They have to go to a drop-off point outside of their residences for exchanging the kids. They have to communicate in writing and emails. So there are some restrictions, if you will, but not the full bore that the appellant is asking for. And then finally, we're asking for attorney's fees because if it wasn't for this domestic violence issue, we wouldn't be here and these parties would be living happily ever after, to a degree, I suppose. If the trial court had simply... I like to think positive, Your Honor. But if the trial court had simply followed the rules, affirmed that Rule 69 agreement, kept out any evidence of domestic violence, and then for the appellant to insist that domestic violence occurred in these proceedings, we believe is unreasonable, and we're asking for attorney's fees as a result. If the court
It wasn't really because of what the appellant did so much as that what the court accepted. You know, if the court had rejected it, and they still wanted to maintain that, you'd have a better basis for that argument.
But they brought up the domestic violence late in the stages of these proceedings. We're not arguing that we should have gotten attorney's fees in the trial court, but here we are again, so for that reason. Unless the judges have any questions, I'll rest. Thank you.
Counsel.
Thank you, Your Honors. First, I would like to address the statements that counsel made with respect to domestic violence. Counsel's interpretation of what the statute allows a trial court to find or how the trial court can find significant domestic violence is inaccurate. As noted in our brief, counsel wants domestic violence to be read in some sort of vacuum, that there has to be physical violence, that there has to be a finding of violence under 1330-601.
Don't we have to follow the statute, whether in Title 13 or Title 25, as to what is domestic violence?
You certainly do, Your Honor, and the statute allows for a lot more than just physical abuse or what 1336-01 outlines. That's what I'm saying, is it's not just physical and it's not just these things that counsel listed. It's a plethora of things that the trial court can look at.
But it's combined, it's in statute. It's not an ad hoc determination based upon merely expert testimony.
Sure, the statute outlines the things that the trial court can look at in conjunction with the things that the court, how the trial court can make that finding. For example, under ARS 25-40303A, it allows the court to find by a preponderance of the evidence that there is a significant history of domestic violence. That's how the trial court found it. It is allowed to be that in the statute. It doesn't have to be narrowly defined as counsel would suggest. And I'll also add that simply because the children may like the parenting time or it's working for them does not mean the trial court conducted the appropriate analysis here. The record is very clear with that. At this point, mother would request that the trial court remand the parenting time findings, affirm the findings regarding decision-making, vacate the specific terms, and affirm the decision-making and Rule 69 agreement findings. Thank you, Your Honors.
All right, thank you. The matter is deemed submitted. Decision will issue in due course.